I'm going to go ahead and kick this off. Good afternoon, everybody. My name is Greg Morrison. I am the Vice President for External Relations for the Idaho Hospital Association. And appreciate everybody jumping on today, especially our guest panelists. Really appreciate your willingness to stand for some questions on this important decision that came down from the United States Supreme Court this morning. Looks like we're having a little bit of trouble. Some are having a little bit of trouble coming on to Zoom and decides to update just as you try to join the meeting. So, and that's coming from one of our panelists. So I'm going to give it just a second until I see her jump on. In the meantime, though, what I'd like to do is let everybody know that's on now. I'm recording this session, so if you would like to get a copy of that when we're done, I'd be happy to email it to you. I will put my email address in the chat so you can send me a request, and I would be happy to share that with you once we have it available. Just briefly before I introduce our panel, just wanted to let everybody know from the Idaho Hospital Association standpoint that we are, at this point, we are encouraged and applaud the decision that the Supreme Court came down with today in the EMTALA case. We believe this is a significant step forward to ensuring that our hospitals and physicians can offer critical care without government interference, ultimately improving healthcare outcomes for pregnant women in the state. However, Idaho's abortion law still needs added clarity to protect the health and well-being of Idaho women outside of the emergency room or emergency department. That's the statement from the Idaho Hospital Association. And so what I will do, good to see you, Peg. I will go ahead and introduce the panel. And what I'd like to do is once I introduce the panel, if you have questions, please quickly raise your hand. I'll call on you the best I can based on your name that's in the Zoom here. And go ahead and ask the question. I'll let the panelists decide who would like to handle that question, and then we'll just try and move through and get as many questions answered as possible in the time we have allotted today. So with that, I'll introduce our panel whose cameras are all on here. I'll start with you, Susie. Susie Keller is the CEO for the Idaho Medical Association. Susie, did you want to do a quick introduction?
Sure. Thank you, Greg. I just wanted to, on behalf of the Idaho Medical Association, echo your comments that this decision to put the case back down to the lower courts does provide some welcome immediate relief for women and their doctors in Idaho. But given how much uncertainty there still is in Idaho law, there's still much more work to do to provide that necessary clarity and certainty around protecting the health of pregnant women and to keep physicians practicing in Idaho. So thank you.
Great. Thank you, Susie. Dr. Harmon, would you please introduce yourself quickly?
Sure. My name is Duncan Harmon. I'm one of the maternal fetal medicine specialists here at St. Luke's. I've been here approximately 2 years. I echo Susie and Greg, your comments of welcome relief, but much work to be done.
Excellent. Thank you, Dr. Harmon. Appreciate it. Peg, go ahead and introduce yourself, please.
Hi, I'm Peg Doherty. I'm Deputy General Counsel for St. Luke's Health System. I have been with St. Luke's for 9 years and have been supporting our women's MedOps team and staff since for 9 years, but particularly in the last 2 years since May of 2022.
Great. Thank you, Peg. Appreciate that. So we'll go ahead and get started, and I'll go to the first question. Do me a favor, before you ask your question, could you please identify yourself and which media organization you are representing? So with that, it looks like the first hand that I saw go up was Christian. Farias, I think, is that, if I pronounce that correctly?
That's correct. Thank you so much for holding this press conference, and congratulations on the result of today's ruling. I have a question. Since the injunction was lifted by the Supreme Court in January until today, when it was lifted, actually since April, when the case was heard, until today, how many more women had to be airlifted due to emergencies by operation of the Supreme Court's lifting of the injunction?
Dr. Harmon, do you want me to take that?
Yeah, that sounds great.
For St. Luke's Health System, this is certainly not an answer for the entire state, but for St. Luke's Health System, at the time of the oral argument on April 24th, we had transferred 6 patients out of our emergency rooms or L&D triage to other states for services that were not available in Idaho. Luckily, since then, we have not had additional transfers.
Thank you very much.
Thank you, Christian. Next question. I don't see hands up, so I apologize if I'm missing something. Trying to keep track of this. Any other questions that you'd like to ask?
This is Christian again, and I'm still on. And if you don't mind me asking kind of a follow-on question, this was a big deal at oral argument in this case for the conservative justices, and I'm curious how it operates on the ground at St. Luke's. And the justices, some of the conservative justices had concerns about conscience protections for doctors who may have religious or otherwise or other kinds of objections to providing abortion care. And I'm curious if that's a thing that happens at all at St. Luke's. And if so, how do you accommodate those concerns? One, because the justices obviously made a big deal out of it, but something tells me that on the ground, that's I can't speak for every hospital, but that's something that staffing wise, hospitals already make accommodations for on a daily basis.
Yeah, Peg, I think that might go to you.
Sure. So at St. Luke's, we have had an exception based on physician or staff member's conscience that has been in place well before the trigger law went into effect and remained in place subsequent to the trigger law going into effect. There is a process for a staff member or a physician to express their desire to not participate in a particular service due to a firmly held religious or conscience belief, and we accommodate that. I think the only exception for that is in an emergent circumstance, and that is only until someone else can step in. That is our process. That is our rule at St. Luke's. And like I said, it has been prior to the trigger law and continues to be the way that we operate. I am not aware of any situation that has arisen either in an emergency room, L&D triage, or otherwise where someone has exercised that option, but it very well could be and just hasn't risen to the level of requiring legal oversight.
Thank you very much.
Great, thank you, Peg. Thank you, Christian. I'll go to the next question that popped up, the next hand. Shannon King, go ahead and identify yourself and what media outlet you're with.
Hi, this is Shannon Mowdy with CREM 2 News out of Spokane. This morning, AG Raul Labrador said that Idaho's law is very clear and that there is a pro-abortion agenda that is trying to confuse doctors in the state and make them believe that they stand to be prosecuted. Looking to see if anybody wants to react to that. And then to follow up on that, if Dr. Harmon may be able to speak a little bit about what is actually happening on the ground for providers and what the environment has been like since this law has been in place.
Thanks, Shannon. We'll start with the first part of your first question. Anybody on the panel want to take a shot at that? The AG's comments this morning.
This is Susie Keller with the Idaho Medical Association. I will just say that the AG's comments from what I saw and what I've read, focus on the life of the mother. And it is true, and the law is clear around preserving the life of the mother. However, what this whole case is about and what our physicians and our patients are very concerned about are those situations in which a pregnant woman's health is in jeopardy, that she is on a track to lose her fertility or a major bodily function. And that is not clear in the law. And so that's really the clarity that we are seeking.
Thanks, Susie. That was a good response. Dr. Harmon or Peg, would you care to add anything to that?
I have not seen or read the AG's comments. I am boots on the ground today in the hospital. But Shannon, if you wouldn't mind just repeating the second portion of your question so I can answer it adequately if you don't.
Yeah, just what has it been like for physicians like yourself who are boots on the ground, who are seeing these patients every day or every week? Is there a lot of confusion among patients, a lot of confusion among physicians about the laws, and is there fear right now? What's the environment and the atmosphere been like with these laws in place?
Yeah, great question. So I think first off, there is confusion both from patients and providers about which scenarios or in clinical scenarios, how sick someone needs to be for it to be legally clear for us to proceed with appropriate medical care. In the context of EMTALA, prior to this day, clinicians had protection in providing medical stabilizing treatment. And it's quite reassuring to see in the most recent decision that that stay has been dissolved. In the setting of my world, unfortunately, many clinical scenarios and potential deterioration doesn't simply exist in the emergency room setting. And there are clinical scenarios and medical health conditions of which EMTALA may not provide me coverage in providing appropriate medical care or evidence-based medical care. And those are the conversations that we have with our patients to educate them around the clinical scenario.
Oh, you muted yourself, Dr. Harmon. Sorry.
My apologies. The current state of affairs is that there are many clinical scenarios where patients are not necessarily in an emergency room setting or need to be provided medical stabilizing treatment, but they have a pregnancy-related condition which evidence-based medical care would be discussing termination of pregnancy. And those are patients, and we as clinicians must explain to them that even in the lifting of the stay, we cannot provide them evidence-based care in this state. And that's where the potential fear as a clinician exists of criminal prosecution or losing the medical license, and the significant financial, emotional impacts to patients that if they so choose to move forward with appropriate medical care and termination of pregnancy need to travel out of state. And I think many of our patients have shared or opened up about those personal stories of trauma surrounding just an awful situation of a wanted pregnancy of which they felt stuck between a rock and a hard place.
Great, thank you, Dr. Harmon, appreciate that. Next question will go to Maureen.
Hi, this is Maureen Grappi from USA Today. Sort of related to that last question, can you talk about how much this decision goes to for any doctors who are considering leaving Idaho? And we've heard about doctors who have. How much is this decision might it convince them to stay in Idaho, or is there still too much uncertainty that you don't see it really making much of a difference in that regard?
Maureen, two of my colleagues left simply because of the change in the trigger ban, and despite the EMTALA decision and the ongoing legal battle prior to this day, another colleague left. We've had our general OBGYN colleagues leave the state based on the current climate and the remaining uncertainty. And I'm unsure as to what this decision today or the news around the likely decision from yesterday has on its impact on whether to stay or go in the future. But I think it's quite clear based on the exodus in the last 2 years since the Dobbs decision that this plays a big role in whether clinicians choose to continue practice and the potential impact of young clinicians finishing their training and choosing to move to our state to provide medical care to Idahoans. It is a large portion, or can be a large portion, particularly in women's and children's healthcare.
That was a great answer, Dr. Harmon. Maureen, I might just add from the Hospital Association standpoint, we know also that there are several of our members that are struggling to hire OBGYNs or maternal fetal medicine docs as well. Those searches are going sometimes 6 months, 8 months, even up to a year before they can find somebody that's willing to come and practice that kind of medicine because of the points that Dr. Harmon said, especially those looking to do residencies and then stay in a state. That's even more difficult to try and get right now for the state of Idaho because of it. And that's really, like Dr. Harmon said, since the Dobbs decision.
Oh, yeah.
Peg or Susie, would you care to add anything to that, or did we cover it?
You got it.
Okay.
I think so.
Thanks, Maureen. The next question is with Julie Lucetta.
Hi, this is Julie Luqueta from Boise State Public Radio. I have two different questions. One is, this seems to have kind of kicked the can down the road, and spoke to a few folks from across the spectrum and everyone seems disappointed. So you've mentioned some temporary relief around the ruling, but it doesn't really provide a real resolution. So I'm kind of wondering if you can speak to that a little bit more. And then my second question is, every time we have, excuse me, a decision, a ruling or something like that, there's like a split reality where one side says a very specific set of facts, and then the other side says the literal opposite or denies it. And so I'm wondering how to navigate this landscape where there's absolutely no agreement on the reality that is happening in Idaho.
Susie, you're still on mute, Susie, there you go.
And I apologize, Julie, will you repeat the first question? I was listening so intently to you.
Thank you.
Okay,
No,
I forgot the first one too, Susie.
Sorry. The first one is, everyone seems to be disappointed on both sides. This just kind of kicks the can down the road. And so I wonder if you could talk a little bit more about what comes next. And my
Sure.
understanding is litigation for quite a long time to come. And so that was the first part.
Sure. And I would liken this this course we've been on with court rulings and injunctions and being taken away and reinstated. It's a roller coaster, and every one of those decisions has a significant impact on care delivery in Idaho. Patients are in a situation where they're not being able to get care that they had previously. And so all of this speaks to the need for clarity in the law to provide that stability and to make sure everybody is on the same page. So we don't have time to wait for the court process to grind through the months and years to come. Idaho is in a situation where we need relief now. And we believe that comes through the Idaho legislature acting to change the law to add a maternal health exception, because we know that will bring clarity, it will stabilize the environment, it will hopefully keep physicians here, and it will make Idaho a little more attractive in recruiting physicians to the state, because then we won't be an outlier with other states that are trying to recruit OBGYNs.
Excellent. Well said, Susie. All right, thank you. Maureen and Julie, if you could put your hands down, and if you have follow-up questions, that's fine. raise your hand again and you'll get back in line, but I want to continue to go through the list here. The next on the list is
Greg, actually, I apologize for interrupting. I think Julie had a second question, which of
oh,
course I
right.
can't remember that one either.
Sorry, I was really excited to ask my questions. Just the second part is, how do you navigate this landscape when your counterpart in this discussion does not agree on the reality and the facts that you report?
I'm going to defer to Dr. Harmon here in just a moment, but for those of us who are advocates, all we can do is keep reflecting the reality of the people we represent, who are the ones who are on the front lines taking care of patients. I'm sitting in an office, lawyers are sitting in their offices, legislators are sitting in their offices, but Dr. Harmon and his colleagues are the ones who are taking care of patients. So all we can do is keep elevating our stories. And with that, I'll defer to Dr. Harmon.
Well, and before Dr. Harmon, I don't mean to preempt you here. I just wanted to add to Susie's comments too, for Julie's, for everybody's edification. You know, we're having some issues, and this is the reality. Whether the elected officials choose to believe the reality, we can't force them to do that. But the reality is that we have some hospitals in our membership that are closing their whole L&D, or excuse me, labor and delivery departments. For a whole host of reasons. One of those reasons is the lack of, or the inability to find OBGYN docs to be able to staff those hospitals. And in some cases, those are rural hospitals, which then require patients in those rural communities to drive the better part of an hour or more just to get to the next city where they can have that care that they used to be able to have in their rural community. So it's a reality, and we've seen it, we can document it, but whether they choose to believe it is up to them. Dr. Harmon, thank you for letting me preempt you. Go ahead.
No, I think Julie's question is a broad one, and I have more of like an existential view of that this is clearly a very charged issue, and people come and approach this issue from different religious, social, socioeconomic backgrounds and personal experiences that shape how you view abortion. And as medical healthcare providers, our medical training and our experience with our patients shape and view how we discuss treatment of healthcare. And we and I spend time educating patients that termination of pregnancy may be a part of a medical recommendation that I make to them in order to preserve the health of my patient, which is first and foremost the mother. It is difficult to accept some of those things if you've never experienced them or never seen them. And there are many clinical scenarios where the idea of abortion as a healthcare option is very gray or unknown. And so I think many times there is an emotional charge to dispute what we as clinicians and hospital systems are stating as fact, simply because you may or may not have experienced it, or it's difficult to believe. But when we see these patients in the clinic scenario or in the hospital scenario, in the emergency room, in the operating room, they are living it, and they understand that this is an option or a medical decision-making that they're involved in. And many of these patients are in a scenario where this is a wanted pregnancy. And I just think it's quite tough to mesh all of these emotions and facts together, and what makes this such a charged issue, both politically. I'm trying to speak from a scientific perspective. And many of our patients who are living it, it's just hard for, I think, politicians and elected officials, if you've never experienced it or seen it. And that's why we really appreciate patients sharing their personal stories to try to educate those who've never experienced it or seen it themselves.
Great, thank you, Dr. Harmon. Now we'll go to what it shows on the screen is KMVT. I believe that's Spokane.
Hi, my name is Maitana Due from KMBT. We're in Twin Falls.
Oh, my bad. Sorry.
No, it's okay. My question is, the Supreme Court is discussing if emergency pregnancies can get an abortion if the mother's life, well, not just if the mother's life is at stake, but if she is having complications when she's delivering the baby. What emergencies in specific would be allowed if this passes?
Let me see if I can put a finer point on that question. I think, so basically what the Supreme Court addressed by basically pushing this back down to the Ninth Circuit Court is now if, and Dr. Harmon, please correct me if I'm wrong here, but I think you're asking what kind of situations in an emergency room, now that the Supreme Court has made their decision, now allows doctors, at least in the emergency room setting, to consider the health of the mother if she comes into an emergency department and is experiencing complications. Whereas before this decision today, there was concern that that was not allowed to be done in an emergency department setting. Outside of that, and I think you talked about this already, Dr. Harmon, outside of that is the bigger question that remains moving forward, is having that same health of the mother consideration outside of an emergency department. Is that kind of what you were asking?
Yes, correct.
Dr. Harmon or Susie, whoever?
Yeah, I'll try to highlight maybe a clinical diagnosis that I think is being discussed, particularly in the state of Texas, premature rupture of membranes, preterm premature rupture of membranes, or PPROM, where the bag of water breaks prematurely before the age of viability, which is roughly 23 to 25 weeks of gestation. Data would suggest that women who experience PPROM, 60% of those women will experience some sort of morbidity or complication, health complication like transfusion or infection. And even if that patient has no evidence of labor, no evidence of bleeding, and no evidence of infection, that patient, because the bag of water is broken, remains at risk. And clearly someone without any of those symptoms may not necessarily be in the emergency room, but be in my clinic where I'm discussing the potential implications of continuing the pregnancy. And that is an option for them. There are other significant risks to the fetus that they need to consider. But in order to preserve the potential health of them, let's say PPROM occurs at 15 weeks, and to get to viability, that's another 2+ months before we can even reach a point at which the fetus can survive outside the womb. That woman is at risk of developing those complications. And so one medical option for them is to proceed with termination of pregnancy to preserve their own health, even though that situation has not yet risen itself to the level of needing to present to the emergency room. And again, 60% of women will experience that outcome. Many of those women may experience that outcome either at the limits of viability, where a baby is born and has significant long-term complications due to prematurity, or is born before the cusp of viability, of which they die because medical techniques, sizes of endotracheal tubes, IV lines, et cetera, cannot fit into that small of a baby, and yet they still experience that adverse outcome. And so these are scenarios of which we have no potential coverage because we know that that threat exists to their health, although it has not yet developed, and certainly we would all argue that they're not on death's door.
That was an excellent answer, Dr. Harmon. Thank you for that. The next question, I believe it's pronounced Nadia.
Yes, hi. India from USA Today.
Oh, okay.
I was wondering if you could talk a little bit more about what guidance Idaho hospitals have given their employees in emergency rooms about what this decision means for them and how that guidance was communicated.
Peg, that might sound like a question for you.
Sure. Well, I can speak to the guidance that St. Luke's Health System is providing for its providers and staff. And we have a very robust communication mechanism. It's an internal internet that allows us to push out communications to staff regardless of what shift they work. But essentially the communication is that any pregnant patient who presents to an emergency room or to what we call L&D triage, which is part of the emergency care that is provided, can receive stabilizing treatment, even if that stabilizing treatment means a termination of the pregnancy, without fear of criminal charges or legal repercussions. And this is a result of the injunction that is in place because the U.S. Supreme Court has kicked this back to the Ninth Circuit and lifted their stay. So it's a pretty straightforward communication that we will be providing that stabilizing care in emergency rooms and in our L&D triage. And that's true even if it is to protect the health of the pregnant patient in an emergency medical situation and not just to prevent the death of the patient.
Great. Thank you, Peg. Appreciate it. India, thank you for the question. Next question is from Brian Holmes.
Yes, hi. Just maybe a question for Peg or Dr. Herman, either one. But first and foremost, prior to the injunction being, I guess, reinstated, we spoke with Attorney General Labrador this morning. We said that anybody that interprets a law the way that it has been interpreted, either they're being misled or they don't understand the law the way it's written. Correct. So the injunction is not needed, is basically what he's saying. And secondly, I guess this might be for Dr. Harmon, that he said that any patients that has been sent out of state to retrieve or to achieve or receive medical attention, it wasn't necessary. It was not medically necessary to do so. Those are his beliefs. And I kind of want to get a response to both of those.
Peg, do you want to take the first shot at that?
Well, I think Dr. Harmon's going to be able to provide the more substantive answer, but
Okay, that's
yeah,
fine.
I think, you know, I think what the Attorney General is saying is that he's interpreting that medical judgment of the physician to perform the abortion to prevent the patient's death in a manner that makes sense to him. However, there is a clinical and an approach by physicians based on their experience and expertise that maybe doesn't align with the way that he's thinking. And Dr. Harmon, you can certainly articulate that more clearly from a clinical perspective.
Well, I think maybe too, Dr. Harmon, you sort of already addressed it with your example of the scenario where the bag of waters breaks prematurely. I mean, is that a fair assessment?
Yeah, I mean, both India's question, Brian's question, do we have a list of conditions? It's quite hard to come up with a long list of conditions of which these are acceptable scenarios, or that we would ask the legislator to be more clear and just list a bunch of diagnoses where it is acceptable to proceed with abortion as a medical option. The law states in Idaho that under my medical judgment, I can proceed with an abortion in order to save the life, to prevent the death of the mother. But that clearly, I'm not a legal scholar. I'm a clinician. I trained in medical school and not law school. And those who did take the law school training route, they also, Pregalar et al. Have argued that law is not clear. In fact, many of the justices thought that was unclear. And I'm simply trying to provide evidence-based medical care. There are so many scenarios where women are not at death's door. They're not in the hospital. When I see patients who, as a child, they were born with a congenital heart lesion that was repaired with open heart surgery. When they become pregnant, they're at significant risk of a change in their cardiovascular system that may cause heart failure or an arrhythmia and put them at significant risk of needing reoperations on their heart or long-term heart follow-up. But that doesn't mean that they will die, but they will experience significant health complications. And maybe they didn't know those things before they became pregnant. And pregnancy termination may be an option for them if their risk is 30% of developing heart failure and needing a heart transplant. These are just another salient example of a patient I may see in my high-risk clinic that is not in the emergency room, that might not be under the guise or coverage of EMTALA if they experience it. I want to prevent even that. And so I'm operating under my best medical judgment, and in the cases of which we've sent patients out of state, either in the hospital or counseled them on the significant risk in the outpatient setting, and they've traveled by their own private car out of the state, they have made those decisions with us based on the risk calculus to them of their health deterioration. Based on the wording of the law, I don't have the ability to pursue the termination of their pregnancy in the state unless unless it is to prevent their death. And where that line is remains unclear to me. And so I'm operating under the best judgment, which is my own, and oftentimes in consultation with my colleagues or legal experts.
Great. Thank you, Dr. Harmon. Moving on to the next question, Rachel Sun.
Hi, Rachel Sun. I'm reporting for the Lewiston Tribune and Northwest Public Broadcasting. I had a quick clarifying question and then one other after that. Greg, you had mentioned that several hospitals have closed their labor and delivery units, and I was wondering what the count was for that now. I know a couple of them closed pretty shortly after the Dobbs decision. I wasn't sure if there was more in the past year or so that had closed.
Yeah, I believe there is actually the most recent is in Western Idaho. And I apologize, Rachel, I'm drawing a blank at this point, but this was just maybe at the most 2 months ago.
Is that West Valley, Greg?
Yes, thank you, Peg. It was West Valley.
Got it. Okay, and the second thing I wanted to ask was I think all mentioned that this is a step forward, but first of all, not necessarily permanent and not enough on its own. And I think Susie spoke a little bit to this, but could you discuss the specific protections that are necessary for doctors in Idaho to confidently provide standard of care for pregnant people?
Sure, I'll take a stab at that and then would invite my colleagues to chime in as well. As has been stated, we've been operating with this law since August of 2022. The law very clearly states the exceptions to prevent the death and in the case of rape and incest with a police report. This EMTALA injunction does allow care for health complications only in very narrow situations, in an emergency and in an emergency room in a hospital. So there are a lot of situations that aren't necessarily covered. And I'm sorry, I lost my train of thought. Could you please repeat the question?
Yeah, no problem. What specific protections are necessary
Right.
for doctors to provide standard of care?
Correct. Thank you. So what we know from what our physicians have told us, there's so much fear and uncertainty due to the lack of clarity in the law. Evidence-based standard of care allows physicians to interact, to provide care to patients if they so choose, to protect their health. So that's one of the main things we know. There are other exceptions in the law that would make it better for patients to be able to receive that medically necessary care. But the maternal health exception is probably the biggest protection, the biggest change that we need to make to Idaho's abortion ban. And as I stated before, one, it provides a little bit more stability and clarity in the law where physicians won't fear criminal charges, civil liability, and loss of their license for following evidence-based care, that they can take care of those patients. Second, it will stabilize our workforce. We have been losing physicians steadily since the law went into effect in August of 2022. We've lost about 22% of our practicing OBGYNs in the state of Idaho. So we need to, as I say, stop the digging of this giant workforce hole. So that will help stabilize the environment. And third, it will help with recruitment because, as I stated before, it will put Idaho more on par with other states with abortion bans that do have an exception for the health of the mother. It will help us to not be an outlier. We're already an underserved state with physicians, and our law truly makes us more unattractive compared to other states that are also trying to attract OBGYNs. So really the biggest fix right now is the health exception, but we also feel more needs to be done.
Well said, Susie. Peg or Dr. Harmon, anything to add?
I think the only thing I would emphasize, and Susie touched on this, is that the penalties under this law are criminal penalties. So it has a different impact on physicians, and Dr. Harmon, don't let me speak for you, but when you are facing a criminal penalty, that is very different than a standard malpractice action that doctors know can happen when there's a bad outcome. So that also instills that caution and that fear in our physician workforce. So you asked, what we could do to give comfort to the physicians so that they knew where the lines were and what they could do. Well, not criminalizing medicine would be a huge leap forward if we just trusted their expertise and allowed them to practice medicine. I think that would be a significant change that would help.
Agreed, Peg. Good point. Thank you. Okay, I think next question we're on to Kay with Coeur d'Alene Press.
Hi, thank you. Given the ambiguity and the confusion surrounding discussions about abortion in Idaho, I wondered if each of you could share what's the most important thing that you want Idahoans to know or to understand about Idaho's abortion ban and how it affects women and families in Idaho?
That's a good question, Kay. Thank you. Who wants to take a shot? Susie?
I'll jump in and just say that it was clear that Idaho policymakers wanted to ban abortion in our states. And the impact and the effect of the law has been disproportionately felt and have individuals in very traumatic, difficult situations. And these individuals that I'm talking about are women and families who want to be pregnant and who are trying to bring a baby into the world and expand their families. Obviously, those who want to seek abortions for any reasons, those folks are impacted. And in the meantime, I think women and families who want to have children are being disproportionately impacted and harmed by this law.
Great, thank you, Susie. Anything else to add, Peg or Dr. Harmon? Nope. Okay. Moving on, next question is with Monica. Is it Carrillo?
Yes, that's right.
Go ahead, Monica.
Awesome. Hi, my name is Monica. I'm the Hispanic Life and Affairs reporter here at the Times News in Fun Falls. Thank you guys for doing this. This is really helpful. My question is, there are large Hispanic communities in rural areas in southern Idaho, many of them being at least 50%. Could you speak on how the abortion laws have affected them most specifically, especially through language barriers? Have you guys been able to provide translated material? Or how are you able to inform them of these ongoing decisions and challenges, especially if there is a language barrier?
Thanks for the question, Monica. Panel, who'd like to try and take a shot at that?
Well, I can jump in a little bit. We at St. Luke's, we do provide translation services and interpretation services for all patients. So if there is a communication barrier, we recognize our obligation to provide effective communication. So we have in-person interpreters as well as what's called VRI, a video interpretation service that can be available immediately for patients. Our goal is always to effectively communicate with our patients. And that would be true regardless of the situation that they are in. So I wouldn't say that the abortion law has impacted that. That is an across the board service that we provide and strive for.
Thanks, Peg. Dr. Harmon, did you want to add to that?
I think I would add in the context of discussing pregnancy complications and abortion as healthcare for our patients who have language barriers or different socioeconomic status, or have an undocumented status, or have no insurance coverage, those patients are disproportionately affected because the health conditions, fetal or maternal, that patients experience don't know any boundaries of language or immigration status or insurance coverage. Yet when those patients who are experiencing hardship also face medical health complications in pregnancy, seeking out-of-state care can be a almost insurmountable burden to those patients. And so those patients, at least in my personal view in counseling them in the clinic or in the hospital setting, seem to face more barriers than those with insurance coverage, financial means, supportive community, and no language barrier to understand the context of which they're in. We do everything we can to help patients and plug them in with financial resources. We spend the time that we need to ensure that they have a good understanding of their scenario and they have some autonomy in their decision making. But I think to your point, Monica, it does disproportionately affect those patients, and that does not go unnoticed.
Right. Thank you, Dr. Harmon. Appreciate it.
I have a follow-up question with that. Do you guys know how many translators or interpreters you guys have on staff?
That might be a tough one to pull out of our hat.
Yeah,
Monica.
I'm sorry, I don't know the number.
Thank you, Monica.
I would say I know of at least 6 or 7 of them that I see through my clinic as in-person interpreters for Spanish.
Next question is from, I'm not going to even try the last name, Kate, but go ahead. I don't want to butcher it.
Thank you. Peg, I understand the hospital communication that you described putting out after the Supreme Court opinion, but you've also talked about the chilling effect of criminal penalties. So I'm wondering if you or Dr. Harmon as a clinician think that the Supreme Court's opinion has reassured doctors enough to overcome that chilling effect, or do you think they will still be too afraid of criminalization to provide abortions where they're needed to stabilize?
Well, I think that the restoration of the injunction is going to provide some breathing room in those emergency situations, and physicians are going to feel confident that they can make the recommendations to their patients, knowing that that follow-up sentence is not going to be, but we will have to look to transfer you to another facility. So I think those conversations will come easier, and the care that we can provide will not be delayed as a result. But I think Dr. Harmon can speak to the fact that there are many circumstances that are not going to fall within that EMTALA umbrella that are not emergencies. And so I think the chilling effect is alive and well there. But Dr. Harmon, what would you say?
I totally agree, Peg, that it does provide some relief in the scenarios of which EMTALA has provides coverage for both us and the patient in the emergency room or medical stabilization treatment. But at the same time, the examples that I've given through previous questions, anecdotally and from a personal perspective to all of you, I love my job and I love caring for my patients, but just like all of you, to your wives or husbands, if you have children, to your families, my primary devotion is also to them. And the threat of a criminal penalty and jail time impacts me personally and can impact my family. And I want to work in the best way that I can to care for my patients, but I also, just as you all do, love and want to care. My top priority is my own family, and I would need to be there for them. And I would love to be a martyr for my job, but not all of us can do so. And so if the mantra around the Idaho state law is to provide and preserve the health of the mother, then we would just simply ask that it state so.
Great. Thank you both for that answer. Thanks for the question, Kate. Moving on. So before I've got two more questions or two more hands up that I see at this point. Just want to let everybody know we have about 10 minutes left in our time allotted here today. So by all means, we can get a few more questions in. I've got some questions coming from Christian and then India. So Christian, go ahead and ask your question. I'm assuming another one or a follow-up.
Yeah, it's another one. Thank you so much for this briefing. And I'd be remiss if I didn't ask this question. Elizabeth Prelogar, the Solicitor General of the United States, argued this case. She's an Idahoan. Many Idahoans may not know that. She was actually born at St. Luke's. And I was curious if, on a more lighter note, if you can perhaps comment on the way she presented the argument, her performance. This is directed to Peg, since you're a lawyer, but anyone else who wants to chime in, if you would like to comment on how she's presented this case on behalf of the U.S. and also of Idahoans providers.
Sure. Thank you for that question. Yeah, we were, a couple of my colleagues and I did go to the Supreme Court argument. So we did get to listen in person to her argument. And I can't compliment her enough. She has such a sound understanding of the law and of the impact to patients. And I thought she presented the arguments with calm, rational explanations that helped shed light on what the issues are when we are talking about a pregnant patient's health versus preventing the death. I thought she did a fabulous job with that. So we were very fortunate to have her in her position at this point in time to make those arguments. And couldn't be prouder as an Idahoan to be in that position today. Those are my impressions, but certainly Susie or Dr. Harmon, if you want to weigh in on your impressions, do.
Thank you.
I think you spoke for me. Thank you.
Excellent. Thanks, Peg. Thanks for the question, Christian. India, you're up next.
Hi, yeah, mine is quick. I just wanted to clarify, Dr. Harmon was speaking earlier about making decisions about whether a pregnant patient's life is in danger or just their health, and talking with colleagues and consulting with legal. Were you referring to patients that are in the emergency room, cases that would be covered by EMTALA, or other cases?
India, some patients, after they're admitted to the hospital for with a concern of a developing condition, maybe they've been in the hospital 4 or 5 days, and EMTALA may not necessarily cover me as a clinician to proceed even in the dissolution of the stay. And so, an urgent or emergent scenario can develop in the emergency room, it can develop at home, it can develop in the clinic, and it can develop after a patient's been admitted to the hospital for a week. And EMTALA provides a certain time frame or location of which, not rather a location, but a time frame or initial presentation to provide that medical stabilizing treatment, which now may include an abortion. But there are many other scenarios where I don't necessarily have that coverage. And so that was what I was alluding to, is to scenarios where I need to discuss with either colleagues or legal. And I speak in the scenario of India prior to, at least in the last 2 years, where there's been this ebb and flow of we have some coverage with EMTALA, we no longer have some coverage with EMTALA, now we do have some. So there's been this kind of ebb and flow. And so clinical scenarios are presented throughout all of this, these last 24 months since Dobbs. And there's always kind of a, okay, what's the current state of affairs? We must be abreast of what the current legal climate is, into which goes into our clinical decision making in next step.
Great, thank you, Dr. Harmon. Next question. Looks like we've got another question from Scott, or no, I guess a first question from Scott.
Great, thanks. Yeah, I'm calling in from the Idaho Statesman. We talked about clarity in the law. What does that look like, and how easy or difficult would that be to achieve legislation that covers these health-related conditions that would necessitate an abortion? And has the Idaho Hospital Association or St. Luke's or any others worked with any legislators on legislation that would achieve some of these exceptions?
Susie, you
Well,
want to go ahead?
Sure. The Idaho Medical Association drafted and brought language forward in both 2023 legislative session and the 2024 legislative session. So we know how to do it. We know what the words are. We know how to thread that needle to ensure that physicians can take care of health complications and not open the door to open access to abortion, which is what I think a lot of Idaho legislators fear could happen. So we do know how to do it. It's relatively straightforward in terms of the words, but as you can imagine, and as has been referenced before, this is highly charged and highly political, and those are the roadblocks that we run into. That we came a little closer in 2023 than we did in 2024, but yes, we know what the vehicle needs to look like.
And a follow-up, Greg?
Let me just see if Peg wants to add anything to that. I know she mentioned something earlier to a similar question.
Yeah, I mean, I think that the only thing I would add to what Susie has said, and the IMA has worked tirelessly to try and get changes to the law that would help clarify. But I think part of what the IMA has done and what all of the hospitals in the Idaho Hospital Association want to see is some trust with our medical providers, that the legislation needs to empower physicians to use their medical judgment to not only prevent the death of a patient, but to protect that patient's health. You know, we need to trust doctors to do that. And the legislation currently only trusts them to make that decision to prevent the death. And we'd like to see it to do the same to protect the health.
And like you said earlier, Peg, too, with the threat of actually felony criminal charges.
Yeah, it'd be nice to not have it in the criminal code and
Right.
And so what was the opposition in looking forward to 2025? Was it election year? Was it, well, let's wait and see what the Supreme Court does? Was it, no, we really do want to ban abortions for health-related reasons? Or was it just a lightning rod issue in an election year? What were some of the oppositions, and what are what's the likelihood of overcoming those objections in 2025?
Go ahead, Susie.
I think most of what we heard in terms of objections in 2023 was this fear that a health exception would lead to a giant loophole in the law that would allow abortions for any reason. Well, our neighbor Utah has an abortion ban with a health exception, and I don't think anybody would hold Utah out as a safe haven for folks seeking abortions for any such reason. So I think that was the basis of the opposition. How realistic is that? I don't know. In 2024, it was definitely more of, well, let's see how this Supreme Court case comes out. And while that's fine, our view is that regardless of how this case would have turned out, we still need an exception in the law. Dr. Harmon referenced the roller coaster that he has been on in terms of, can I provide this care or can I not provide this care, as each court bounces through its varying decisions and their impact on care delivery in the state. So we will be back in 2025 asking for this clarity. And I think this whole process has proven that we need clarity in the law because there's a lot of things bouncing around. And the opposition has said that they feel like Dr. Harmon can take care of any condition that walks through his door now. We have a different view of that. So if we're on the same page philosophically, let's get it in the law to clarify.
Well said, Susie. We're bumping up right at our time limit here, and I just want to say thank you to our panel and in your willingness to do this. And I want to say thank you to all the media that joined on the call today.